Hello friends, in the series on the income tax cases, today we will discuss a very important issue, and the issue is related to payment made by a charitable organization which is registered under section 12A to the specified persons which are mentioned in section 13 subsection 3. In other words, payment made to the related parties. In the present case, the issue before the Honorable Delhi High Court was that if some payment is made to a chairperson who is serving that society and the amount which is paid to her is according to her experience, qualification and contribution to the society, so whether in that case some disallowance is justified if it is made by assuming that it is not commensurate with her services. This issue has been taken up by Delhi High Court in the case of Commissioner of Income Tax Exemption versus IILM Foundation, and this case is reported in 480 ITR at page number 1. The date of the judgment is 21st April 2025. In the present case, the assessment year are 2009-10, 2010-11 and 2011-12. When the assessment proceedings were going on, the assessing officer was of the view that whatever the amount has been paid to the chairperson as a salary or allowances is not commensurate with her education, qualification, experience and duties, and accordingly the assessing officer made an addition of 30% of the salary paid to that chairperson under section 40A, subsection 2, clause A. When the matter was before the CIT appeal, the CIT observed that the same issue was in the assessment year 8-9, and in that assessment year no disallowance was made. So on the basis of consistency, the CIT appeal said that the amount cannot be disallowed to the assessee. The CIT appeal also examined and recorded a finding that the amount has been paid according to the experience and qualification of the chairperson. When the matter came before the tribunal said that section 13 subsection 1 clause C and section 13 subsection 2 clause C did not bar payment of reasonable salary to any person who is specified under section 13 subsection 3. The tribunal said that if we go and read section 13 subsection 1 and do its plain reading, then from the plain reading it comes out that if any amount paid to the specified person, then it will not be excluded from the total income, or in other words, the benefit of that amount will not be given for the application of the income. But at the same time, the tribunal said that the reading of section 13 subsection 1 also depicts that the exemption would not be available if such amount is applied for the benefit of the specified persons. But at the same time, the tribunal said that if the amount is paid to the specified persons according to their experience, according to their qualification, then it will not be deemed as benefit to the specified persons. Meaning thereby that if any services is received from the specified persons and then the amount is paid to them, then it will not be treated as benefit extended to them, and the payment will be treated as application of income by that society or by that trust who is registered under section 12A. Friends, the importance of this case becomes very important because in the assessment proceedings of charitable organizations, it has been seen that whenever the assessing officer finds that any amount is paid to any persons who are in the list of specified persons which is mentioned under section 13 subsection 3, so they straight away make their mind to disallow that amount without going into that integrity whether that amount is allowed in the previous years or in the assessment of previous years, or whether that amount is commensurate with the services received from them. So in the present case, the Delhi High Court also upheld the order of the ITAT, who has sustained the order of the CIT appeal, which in turn has deleted the additions. At the end of this video, once again I am repeating the name of the case. The name of the case is Commissioner of Income Tax Exemption versus IILM Foundation, and this case is reported in 480 ITR at page number 1, and the date of the judgment is 21st April 2025. Thank you, friends.